cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Especially if you've got a question about wills and estates. Kathy Wilson joins us while David Whiting somehow gets the week off. I don't know who allowed him to do that. We will dock his pay. Kathy Wilson is from Kathy Wilson Legal. Good morning.
Good morning, Raf. He shouldn't be allowed to have a day off.
No,
there's nobody with a knowledge like David of all areas of law.
We should chain him to the desk, shouldn't we?
You should.
We should just do it every day. 1300 222 774 is the phone number, especially wills and estates. If you've got other legal questions, we can try to get to them. Dave is the expert when it comes to things like fencing, but hey, we will give everything a try. Peter is calling from Coburg. What's your question, Peter?
Good morning. I have an estate to administer from my mother who passed away about 2 years ago. We have one sibling who's 1/5 of the estate who's uncontactable. We believe he's living in Cambodia. We've tried everything through DFAT. He probably may not want to be contacted and hasn't responded over the last 2 years. And I need to know what to hold his 1/5 of the estate. Is there a time limit that we need to hold it for? What documentation do we need to prove that, he's not either dead or, what do we do with that 1/5 of his estate, essentially?
Yes, sometimes people do go missing or just don't have any contact with family. In cases like that, you can contact the Senior Master of Funds in court. There's a great fund called the Senior Masters Fund, and money goes into that fund for people with disabilities and things of that nature. But they'll also take money in situations where you can't find a beneficiary. So if you contact the Supreme Court and it's the Senior Master of Funds in court, and they can give you some direction about the payment. You need to set out what it's for and what it's made up of and so forth.
But say it's like, so that doesn't then get redistributed to the 4 remaining siblings?
No.
Is there a time limit, Kathy? Like after a certain time, does it get distributed? Or
no, you can. In some cases, in fact, I acted for one where a fellow went missing in the war in Papua New Guinea. You can apply for what's called a Benjamin order, an order that for the purposes of succession only, the person's deemed to have predeceased the deceased. But that's a very technical application. It's an application to the court. You've actually got to show evidence that they've genuinely gone missing and there's
so
evidence.
If you don't have evidence, the money goes effectively into limbo.
Yes, it goes to the Senior Master Funds in court, and it's invested there. They invest well and they invest wisely. Often, though, you can find people and you can use his share of the fund to find him, not extravagantly, but you can get somebody over in Cambodia to look for him. The fact that the person's in Cambodia or a country like that often means there's a reason he doesn't want to be found.
Okay, Peter, I think that's the best answer we can give you. That okay?
No, not really, because I don't think my mother wanted 1/5 of her estate to go into limbo. I think she probably wanted her children to receive it. And there's 4 remaining siblings, and why does it's $200,000 not be distributed amongst those 4?
Well, might be the law, Peter, but I'll ask Kathy, how do you address a concern like that?
The will says that he's to share in the estate. If there's a will, is there a will?
Yes, there's a will. It says to be divided by 5.
5 times.
And that's what your mum put in her will, so you can't just change it. In some cases, you can get an indemnity from the others and pay it out, but it's a real risk for the executor because if the person turns up, then you're going to be liable to pay them. So you're much better off. I understand what you say, but your mother's will did say 5ths, whether she didn't get around to updating or whatever happened. The reality is that it does say 5ths, and you can't just take his money and allocate it to somebody else.
Peter, good luck. I think that's an answer you didn't like, but I think Kathy's given you a pretty good overview. It's 11 minutes past 10. You can hear the real feeling and concern in his voice, Kathy.
Yes.
I imagine that happens a lot with wills and estates. Like these things matter deeply to people, don't they?
Well, they do matter, and sometimes it's because the person who made the will didn't update it. Sometimes it's because they have a particular view about a child or another, or they favour one or another. There is a possibility to make a claim against an estate if you're a family dependent and you haven't been provided for. But otherwise, we start from a proposition that it's your money. You can do what you want with it. It's really only if there's a legal obligation that arises because the laws say that you must provide for those that are financially dependent. So if you think of a long-term partner, for example, I had a lady who'd been married for over 50 years and wasn't even left enough to buy a little house, and the money all went elsewhere. And of course, the court says in those circumstances, if you've got a long-time partner, you really need to make sure they're provided for. If they've got their own funds, it's different.
So we're talking here about wills and estates. How many people die without one? Is it common?
It's more common than you might think. I'm thinking of the statistics now that in the previous annual report, I think it was 11%, but I may have that wrong.
11% of people
die without a will.
Right.
And sometimes that's because they think it's a bad feng shui and all those sorts of things. Sometimes they don't get around to it. Sometimes it's too hard. Sometimes they don't think they've got assets of value. But, for example, if you own a house or if there's money in a super fund, it might be paid to the estate, and then probate is needed. Now, if you don't have a will, there is a scheme, a distribution scheme to divide up money. So if you've got a spouse, it'll go to your spouse. If you've got children from prior marriage, then there's divisions of the money. And if you've got multiple spouses...
So there's a template there.
There's a template there. So
right.
there is and then if you haven't been provided for, you can make a claim against the estate if you are a family dependent. I'll put it loosely like that. It's not just anybody.
You've got to show you need the money, though.
You've got to show the need.
Dependent.
Yes, you've got to show the need, and you've got to show your relationship.
Okay. If you've got a question for Kathy Wilson, especially about wills and estates, 1300 222 774. You might just even want to know the basics, how to begin to work out what should or should not be in your will, like where do you go to start a will? Any of those sorts of questions. But Tim is calling from Ringwood. What's your question, Tim?
Yeah, g'day. My dad, late father, passed in January. He had a will, and part of it split three ways. My sister, he wanted funds to go into a trust, so I went to the bank and took the probate there, and they said, "Yep, no problems. We'll use the probate to set up the account, and we put that all in trust, and it's in a term deposit, and that's fine." But part of the will, it grants us from time to time we can give her a lump sum so that she can make a purchase for a car or things like that, and that's come up within the first 6 months, and she wants to get a car, and I'm wondering, how do I approach Vic Roads can I use probate instead of a deed of trust to register a vehicle? Because I'm sort of getting the runaround from Vic Roads. They're just saying, no, you need a deed of trust.
So it depends on what the will says. When you say she, do you mean his partner?
My sister. So
your sister.
One of the beneficiaries.
Okay.
Right.
Yeah. So it depends on the type of trust it is, but it shouldn't stay in the name of the trust. It can't for a car. You need to register it in a person's name because a person has to take responsibility if there's a car accident for insurance and things like that. Insurers won't register a trust. They register a person. It depends on your driving record and things like that. But depending on the provisions in the will, you could make a payment to her. You could make a loan to her, and she could purchase the car in that name, and it could be secured. You could have a document drawn up to protect it. But oftentimes you better just distribute the money to her. If she can drive a car, give her the money to buy one.
I was hoping to register it under the testamentary trust and then appoint myself, because in this case, it was can I buy a car? Yep. Okay. Can I just transfer the funds to a partner who might buy a car? And I was okay, what's going on here? That's why the trust was set up, to try and protect it from being taken advantage of.
Okay, yes. No, you can't. And you wouldn't want to be liable if they had a car accident or didn't have it insured or something like that. So I wouldn't do that.
Someone's got to own the car.
Somebody's got to own the car.
Yeah. Sorry, Tim.
Yep. Cool. Thanks.
Good luck. 1300 222 774 is the phone number. Taking your legal talk back at 16 minutes after 10. Kathy Wilson is with us from Kathy Wilson Legal. If you've got a question about wills and estates, we'll try the complex ones. We're happy with the simple ones as well. I did not expect to get a question about if you could register a car in the name of the estate. So there you go. Peter is in Greensborough. What do you want to mention, Peter?
Hi, good morning. I've got a question, a little bit of context. My partner and I aren't married. We've been living together for 25 years. Our wills are made out to leave everything to the other. If one of us died, would it be necessary to get probate, the other one to get probate? And is that need to get probate influenced in any way if you register a relationship with birth, deaths and marriages?
They are all good issues to discuss. You have a right under a will if you're a domestic partner, whether it's registered or not. Registration helps because it proves the relationship. Your other question was whether or not you need probate. Now, that depends on what the asset structure is. So if the assets are jointly owned, for example, your house is registered in your names as joint proprietors, not as tenants in common, as joint proprietors, then you don't need probate for that. The law says you're automatically entitled to it. You just register a survivorship application. But if there are assets of some value just in the name of one or other of you, then you need probate. And probate is an order from the court verifying the validity of the will at your appointment as the executor. So can I ask, is your house jointly owned?
No, it's in my name.
Okay.
And both of us have, reasonable assets which are in our individual names.
Yeah. It's certainly for you, you would need probate because in Victoria you can't deal with property without a grant of probate. If there are other substantial assets, you'd also need probate.
Okay.
So the birth, deaths and marriages registration, that would help the situation, or does it not really make much difference?
Well, look, it helps because it proves you're a relationship. If anybody's challenging it, it proves it. So it's a helpful thing to have. It's a statement to the world that you are in a registered relationship and you both recognise that as such. So it's a helpful thing to do.
Okay.
Okay, thank you.
That's
Good luck,
a pleasure.
Peter. Maybe you can have a glass of champagne when you get the certificate as well.
That's
Maybe.
right.
I don't know. Only if that's appropriate for you. Give us a call. Got a question about wills or estates? 1300 222 774.
This is ABC Radio Melbourne with Raf Epstein.
Trying to answer your questions about wills and estates with Kathy Wilson. Sophie is calling from Traralgon. What's your question, Sophie? Oh, Sophie, hold on one tick. Sorry. Forgive me, I didn't press the right button. Totally my mistake. You'll need to start again. I'm sorry, Sophie. What do you want to ask us?
So my son took his life 4 weeks ago in intestate.
I'm sorry, Sophie.
His ex-girlfriend is, of course, trying to contest, and but I'm just wondering the legal standpoint, if it's proven that she was in an immediate relationship before he died. How does the law stand if it was non-exclusive?
This is a tricky question, but interesting for people to know about. I'm very sorry, firstly, about your son. It's hard enough going through the grief and the loss without having to deal with these sorts of issues. If I was you, I certainly would get a lawyer because I can tell you if the ex-girlfriend is making a claim, it's not going to be easy. So I'd suggest you contact the Law Institute and ask for a lawyer who's an accredited specialist in wills and estates, or if you're speaking to a normal lawyer, just ask them what experience they actually have to tell you exactly what experience they have. And if they just say, I've done tons of it, well, that's not the answer. You want some examples. The situation is if he died without a will, if he was in a relationship with her, there are factors that determine whether you're in a relationship or not. And they are things like the degree to which you said you're in a relationship, if you had joint accounts, if you lived together, but it's not critical that you live together. So there are a whole shopping list of factors that are taken into account to determine whether or not you are a partner. Now, if she is a partner, if she's deemed still to be a partner, and that sounds unlikely if she truly was an ex. I've had people say they were an ex and they weren't an ex, but if she was truly an ex, then she could still make a claim against the estate, but she wouldn't automatically be entitled to anything. So under the laws of intestacy, if your son has a partner or children, they come first. Otherwise, it's their parents, both of them, if you're still with your partner, and they have a right to take out what's called letters of administration if there's no will. If there's a will, it's the executor named in the will, and then the ex-girlfriend could make a claim and say she was dependent upon him for various reasons.
But no will, Sophie, is that correct?
No, he actually wrote an arrangement of affairs himself, and
that
stepped out what he wanted because he'd actually removed her and her belongings from the house 3 weeks before.
That's important info, I
No,
think.
that's really important information because sometimes a document can constitute a will, even if it's not written out as a formal will with two witnesses that says this is a will. So I definitely take that along. I would definitely see an accredited specialist. So if you ring the Law Institute, they'll refer you to they'll give you the name of an accredited specialist in your area. You should take that document in, or if it's on a mobile phone or wherever it is, on the back of a napkin, take it in and show the lawyer and ask them if this is an informal will or if it might be proved as an informal will. Now, what I mean by that for listeners is formally to have a valid will, you need to write it out. It needs to have two witnesses. You have to sign in each other's presence. But the law recognises now, since 1989, that you can have, 1998, that you can have a document that's an informal will. It sets out your wishes, but it's not properly executed. If it's intended to be a will, it'll be a will. So I definitely take it along and show it to a lawyer.
Does that answer enough of your questions, Sophie?
Yes, it does. Thank you. Yes.
And Sophie, I'm
Thank you
so
very much.
sorry. I hope you've got people you can lean on and talk to as well, okay?
Oh, we've had the most beautiful people around us. It's been wonderful.
Okay.
Yeah.
Good luck, Sophie. Thanks for your call.
Thank you very much.
24 minutes after 10, answering questions about wills and estates. Lee is calling from Mentone. Lee, what do you want to ask?
Good morning. My brother has passed away, and in his will, the lady that has been named as executor doesn't want to take on that position. I'm wondering what the situation is there. It is by no means a big estate. It is only just personal things and his bank account, so we're not dealing in cheap stations.
Yes. Okay, yes. It sometimes happens that people are appointed as an executor without their knowledge. People have been known to appoint the Queen, the Pope and various others. Just because you're named as an executor doesn't mean you have to act. What you do is sign a renunciation of probate, and a lawyer can help you with that, or the probate office can help you with that. And then the beneficiaries under the will, or one of them who's an adult, can make an application for what's called letters of administration with the will annexed. That sounds a bit complicated, but it says the court is appointing you to administer the estate according to the will. That's done by one of the beneficiaries. If all else fails, then go to state trustees, but that's only as a last resort. Normally they can just renounce. One of the beneficiaries can apply.
Okay.
Okay. We don't have an original copy of the will. We only have a copy of the will. Is that still a legal document?
No, not on its own, but sometimes there can be circumstances in which it can be proved as a copy will, but those circumstances are difficult and you need to check with the lawyer, because if the will itself was last traced to the will maker and it's not amongst their papers when they die, there's a rebuttable presumption that they intended to revoke it. It is changeable, so do talk to a lawyer. There will be a local lawyer that will be able to help you with that,
Good
or the
luck,
probate
Lee.
office.
Terrific. Thank you.
Thank you.
And Kathy, if I appoint the Queen,
Yes.
Queen Elizabeth II,
Yes.
or Elvis Presley, as the executor in my will,
Yes.
so they're not around anymore,
Yes.
what happens then? And also, what happens if I appoint Prince William?
Yes.
He's going to be around for a long time.
Yes.
What happens in those cases?
A lawyer wouldn't let you appoint them in the first place without their consent. And sometimes it's an indication that the person doesn't have all their faculties. That's usually the case. Right. So sometimes it'll be...
I guess I'm curious. Let's just say I have a dodgy lawyer
Yes.
who witnesses that will.
Yes.
Does Prince William then need to sign a document renouncing himself or something?
Yes, they will do that. Sometimes the court will, another way is to pass over the executor. That's a formal application to the court.
Okay.
You can pass over the executor.
So my children could say to the court, look, my father was not of right mind.
Well,
Prince
then-
William's not the executor.
No, well, then the will probably won't be valid.
Oh, the
because
whole will would not be?
No, if he's not of right mind.
Right.
If it's
Yes.
just the executor, you can renounce. The executor can renounce. But as I was saying, it's often an indication that the person doesn't have their faculties, so check first.
Okay. Oh gosh, that's an interesting proposition.
Yes.
Diane is in Mornington. What do you want to mention, Diane?
Oh, good morning. I have a strange one. My ex-husband died, leaving $20,000 in a super trust. He has 4 children. I signed a thing to say I wouldn't claim. I didn't know the amount of money in the trust. I have a child support debt of double what he left in that super. The trustee has said he is awarding the whole 100% to 2 minor children.
Yes.
I have a son who's still, although an adult, still dependent on me. And as I say, I initially signed this thing saying I waiver my right. But now I'm wondering, because I do have a legal child support debt, although I closed that case, they said I have a right to pursue it privately. Is it worth getting involved, or do I just walk away?
Worth pursuing, Kathy?
No, Diane. Superannuation is left according to the rules of the superannuation fund, and you need to be a dependent to be eligible to participate. Otherwise, it goes to your estate. Normally, a super fund will look for dependents, and so the other issue is that it's not money from a super fund is not available for the payment of debts. So, in other words, super is outside your estate. If the money is paid into the estate, then you can claim it against the estate, but otherwise it's not available to satisfy a child support debt.
Thank you very much.
That's okay.
Because I didn't want to chew any more broken glass.
No, don't do that.
Thank you so much.
Oh, Diane,
Goodbye.
sounds difficult. An apt metaphor, although a painful one. And Graham's in Corumburra. Graham, what's your question?
Hello.
Hi, go for it.
Hello.
Yeah, g'day. How are we going this morning?
Very well.
Very well. My question is in relation to, I'm a sperm donor and there are 8 donor children out there somewhere. Now, I want to know how or if I can make an allocation for them in a will, and how I would do that when I don't know their names.
Yeah, no, if you're a sperm donor, unless you've retained your rights as a father, and under the donor legislation, you give up your right or relationship with them. So unless they come back into your life, in certain circumstances they could make a claim, but otherwise they have no legal right against you. And you can still leave them money if you can identify them, or if you can identify them as a class, but you're making it very hard for your executor to find them if you don't know. So you can choose to leave them money, but you need to have a way of identifying them.
The only information that I have is sex at birth and the month and year of their birth.
Yes.
So that makes it difficult.
No, the executor could always, that's a very challenging thing to do. I'd certainly see a lawyer before you did it, because you'd want to name them as an identifiable class of people. So if you just say, I leave my money to, sons of timber merchants, for example, not being members of the Communist Party, as happened in one case that I had, is that identifiable as a class of people? So if you can identify a class, you can leave them money if you don't know their name, but you're making it very difficult for your executor. If you can't find their details, the executor's not going to have any greater luck.
Okay, Graham.
Okay.
Good luck.
Yep, that's fine.
Sorry about that.
Thank you.
Thanks a lot.
That's all right.
So did you say someone tried to write a will saying leaving the money to timber merchants who were members of the Communist Party, and that was a real will?
That was a real will. There was a grant of probate quite some years ago now, and the bequest was to the sons of timber merchants not being members of the Communist Party.
Did that stand up?
No.
Right, okay.
It was too vague.
Right. Okay.
So you've got to have an identifiable class. You've got to be able to work out who's in the class and who's out of the class.
Wow, I'm learning things every day. Kathy, thank you so much. Really appreciate your time this morning.
It's been a pleasure. I've enjoyed it. Thanks,
Kathy Wilson is from Kathy Wilson Legal. Every Tuesday we try to answer your legal talkback questions. David Whiting should be back next Tuesday.